Deputy Chief Justice, I propose to address the two reasons for the judgment of the Electoral Court, being the relationship between remissions and Section 47(1)(e) of the Constitution, and secondly, the impact of the appeal proviso. This is a matter of constitutional interpretation, and under Section 176(3)(b), Roman figure 1 of the Constitution, the Constitutional Court has jurisdiction to decide constitutional matters. This is a constitutional matter falling full square within the remit of this court's original constitutional jurisdiction. Section 47(1)(e) of the Constitution is the pertinent provision in this case. It contains eligibility criteria for membership to the National Assembly. Under the section, every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly. 5 exceptions are then carved out, meaning that anyone who falls within the exceptions is not eligible. 4 of the 5 exceptions are not relevant for today. The last exception is at issue. It states anyone who, after this section took effect, is convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct constituting the offense would have been an offense in the Republic. And then, comma, but no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. A disqualification under this paragraph ends 5 years after the sentence has been completed. The section comprises 3 components. The first component is the substantive provision. This is the controlling provision which defines the category of disqualified candidates, being persons convicted of an offense and sentenced to more than 12 months without the option of a fine. The second component is the proviso. This is the part of the section that says that no one may be regarded as having been sentenced until an appeal or the time for lodging the appeal has lapsed. And then the third and final component is the duration of the disqualification. The disqualification ends 5 years after the sentence has been completed. It is crucial to keep those 3 components of the section separate for a proper analysis. I should then address the impact of remission of sentences. The court will remember that the Commission lost the case because the Electoral Court found that the effect of the remission was to reduce the sentence instead of 15 months, rather to 3 months. Firstly, from the plain text, which is what this court has said we should first have regard to in several judgments. What we know from the text of the substantive provision, in other words, the controlling provision, is that a candidate who is convicted of an offense and sentenced to more than 12 months without the option of a fine is disqualified. There is no exception for candidates who received remissions of sentences. No exceptions for pardons. That means that the court can apply the section as it reads. The exclusion of pardons and remissions from Section 47(1)(e) is not an accident of history, but it was a careful policy choice made during the drafting of the Constitution. The history to Section 47(1)(e) bears this out. Section 42(1)(b) of the interim Constitution, which is the direct equivalent of Section 47(1)(e), did contain a pardon exception. In Section 42(1)(b), the last words were, unless he or she has received a pardon. The rest of the words were identical. The pardon exception was fully and anxiously debated at the Constitutional Assembly. A report of the Technical Committee of the Constitutional Assembly of 7 September 1995 shows the express and intentional decision to exclude the pardon exceptions because of superfluity. They found that a pardon expunges the crime and the sentence, and therefore it was not necessary to include it. But pertinently, and more importantly for our case, the drafters also applied their mind to the relationship between the disqualification under Section 47(1)(e) and remission of sentences. They specifically referred to remissions of sentences, which they said could occur, for example, where a person's 20-year sentence has been reduced to 10-year sentences. And then squarely they answered the question which is before the court today. They said in a remission, the judicially imposed sentence is not reduced, merely the length of the execution. And then as to disqualification for the National Assembly, they said, whether a person is disqualified would depend on the length of the original sentence of imprisonment. Two earlier versions of the draft reports dated the 24th of August 1995 and 30 August 1995 confirm this. The use of travaux préparatoires is a vital source of interpretation. Yourselves have heard the same in Makwanyane, in Mansing, in Amco versus Anglo Gold Ashanti. And often travaux préparatoires are an indirect source of interpretation. But in this case, it is a unique circumstance because they are the direct evidence of why a clause in the Constitution is worded the way it is. What is its purpose and what does it mean? Thirdly, the argument about remissions as reducing judicially imposed sentences simply weakens the judiciary. It enables the administration to treat judicial sentences as pro non scripto, an outcome which can only encourage disrespect for the law. That would also threaten some key provisions of the Constitution. For instance, Section 1C, Section 2, Section 165(1), and Section 165, subsection 5 of the Constitution. So in sum, we argue that the Electoral Court fundamentally erred when it held that the impact of a remission is a reduction of the sentence. That is not borne out by the text, it is not borne out by the history, and it is not borne out by the purpose of the section. Let me now consider the second strut of the Electoral Court finding, which was the appeal proviso. It goes to what I've referred to as the second component of the section, which starts with the words, no one may be regarded as. Firstly, let me remind the court that this is a proviso. And second, even in the category of provisos, it is a dimming provision. In its plain text, it dims things to be what they are not. This court will recall the judgment of Chotabai versus Union Government, where it was held that a dimming provision may be employed to denote merely that the person or things to which it relates to are considered to be what they really are not. And as a proviso, it may not distort the substantive provision. It may not undermine the principal provision to which it is attached. To use a proviso to undercut the controlling provision is to distort the law. We have referred in this case to the judgment, I think cited by our learned friends for the amici, the judgment of Mposi, M-P-H-O-S-I, versus Central Board for Cooperative Insurance, decided in 1974, Volume 4, SA 633 at 645, which lays down the principle that a proviso may not be used to undercut the controlling provision. The court must always have regard to the controlling provision. This dimming feature of the provision is also apparent from its content because it says that a person who has been sentenced as a matter of fact and as a matter of law is considered as not being sentenced until an appeal is finalized. It is also of transient and temporary duration. Once an appeal is finalized or the time for an appeal has lapsed, the dimming falls away and the reality of the sentence kicks in. One is no longer regarded as not sentenced. In its essence, it is a sensible proviso. Its purpose is to ensure that the consequences of the sentence should await a stage of finality, which is achieved only after the Court of Appeal. Since the purpose of the proviso is to safeguard finality before the execution of sentence, under section 47(1)(e). The question then arises, what happens when the sentence has been imposed by this court? The original sentence has been imposed by this court. The answer is, it depends. It depends on whether this court is a final court of appeal or not. Since we know that this is a final court of appeal, finality, which is the essential reason for the proviso, would have been reached, and the sentence becomes operative for all purposes, including section 47(1)(e). So it is submitted that the sentence of this court becomes operative on the day that it is imposed. It is not suspended by an appeal because there is none. Finality, which is the real object behind the proviso, is achieved. Next is the finding of the Electoral Court that this court's sentence is not a sentence under section 47(1)(e) because only appealable sentences are contemplated therein. This is the second reason given by the Electoral Court for its order. There are at least 5 reasons why the Electoral Court fundamentally misdirected itself in this regard. Number 1, there is no textual support for that conclusion. Nothing in the Constitution says there is a distinction between sentences of lower courts and the sentence of this court. The proviso in its wording does nothing of the sort. Number 2, the interpretation undermines the authority of the Constitutional Court, producing absurd outcomes. It means that a sentence for the crime of civil contempt of court imposed by a magistrate of more than 12 months without the option of a fine would disqualify a candidate under section 47(1)(e). But the same sentence for the same offense imposed by this court would not. Thirdly, it undermines the purpose of the section, which is to protect the public from lawbreakers now putting themselves up as lawmakers. This protective purpose also safeguards the institutional integrity of Parliament. We have referred in our heads of argument to the report of the European Commission for Democracy Through Law, the Venice Commission, dated the 23rd of November 2018. At paragraph 168, this is what it says. Legality is the first element of the rule of law and implies that the law must be followed by individuals and by the authorities. The exercise of political power by people who seriously infringe the law puts at risk the implementation of this principle, which is on its turn a prerequisite for democracy and may therefore endanger the democratic nature of the state. It is therefore justified to restrict their right, in other words, the right of lawbreakers to be elected. Fourthly, the distinction imposed by the Electoral Court is arbitrary. There is no principled basis and none from those paragraphs that we have referred to in the judgment of the Electoral Court, upon which one can distinguish sentences imposed by this court and other sentences for purposes of section 47(1)(e), merely on account of appealability. Fifthly and finally, it is suggested in the judgment Akua that a reconciliation between section 19 and 47 is necessary because the two are in tension. But this tension, with the greatest of respect, is more apparent than real. Section 19 is a general right to vote and to stand for office. Section 47 is the constitutionally imposed disqualification provision. There is no tension. Section 19 applies to persons who are not disqualified. In order to know whether one is disqualified or not, section 47 is the controlling provision. That is what this case is about. Otherwise, without the disqualification provisions, it becomes a free-for-all. Unrehabilitated insolvents will also contest using section 19, and so will those that have been declared to be of unsound mind by the court. They too will have section 19 rights. The final part of section 47(1)(e) is the duration of the disqualification. That is 5 years after the completion of the sentence. Again, this should have been an uncontentious part even before the Electoral Court. It simply means that a period of 5 years should lapse between the completion of the sentence and the eligibility of a person to contest for the National Assembly. And however interesting, we know the Electoral Court placed great store in this debate. But however interesting the debate about sentence completion, it simply does not arise. If the second respondent had completed his sentence when he was released after remission, that does not change that he fell within the excluded categories in section 47(1)(e). So what we have said so far about remissions and the appeal proviso should settle the debate as to the correctness of the order of the Electoral Court. It is without question born of a misdirection of law, and that is why we say it is your duty to overturn the patently incorrect order of the Electoral Court. You have also asked us to address the court on the distinction between civil contempt and other offenses. The starting point here is the order that you gave in the Zuma contempt case, which is at paragraph 142. And we know from Joqela that the order is the executive part of the judgment. It is the part that operates. You made it clear there that you declared that Mr. Zuma is guilty of the crime of contempt. There was no equivocation whatsoever. We have focused in this part of the debate on South African law, and that is because we could not improve on the learned research of our colleagues for the different amici on foreign and international law. What is the position in South Africa regarding the distinction between civil contempt and other offenses? South Africa rejects any distinction between the contempt of a civil court order and other types of offenses. In substance, the distinction is only in form in the process, which is a hybrid process. But in substance, South Africa treats both of them as crimes or offenses. And it does so for the obvious reasons that if the rule of law is to survive, it needs effective punishments for people who violate court orders and threaten the administration of justice. It does so because South Africa's founding value includes the rule of law. The case of Faki was the first decision to give a comprehensive jurisprudential treatment of the common law on contempt of court under the Constitution. It ultimately concluded that intentional disobedience of a court order is a crime and it is an offense. And since the case of Faki, this court has rendered at least 4 judgments that we could find, which state that civil contempt is an offense and a crime, just like any other. The first is the judgment of Pheko, where you held that civil contempt is a crime. You will see that at paragraph 28 and 31. The second is Machabenk, where you specifically dispelled any notion that there is a distinction between civil and criminal contempt of court, that the latter is a crime and that the former is not. You will see your own finding at paragraph 50. The third is the Zuma contempt judgment, which has become a source of contention in this case. But it also made it clear that our law defines contempt of court as an offense. We see that at paragraph 66. And even the dissenting judgment that has been much vouched for by the respondents, even the dissenting judgment found that civil proceedings in which a private party alleges that a party against whom they have obtained a court order is in contempt of the order and therefore guilty of the crime of civil contempt. You'll see that at paragraph 149 of the minority judgment. And in the fourth case, which is the rescission judgment, this court again reinforced the criminal nature of contempt when it dismissed Mr. Zuma's application to rescind the contempt judgment. And the dissent in the contempt judgment had also described in various parts Mr. Zuma as having been convicted of contempt of court and numerously referred to conviction for contempt of court. We see this at paragraph 149, 151, 173, 212, 218, 228, 232, 244. So there is absolutely no debate that in South African law, contempt of court is a crime. And there is no debate that in South African law, contempt of court is a crime just like any other crime. Where there is a debate, but even that debate was settled, it is what is the procedure for the prosecution of that crime. That debate has also been resolved. In the Zuma case, although there is a strong dissenting judgment, what cannot be mistaken is that the majority judgment is clear on this position, that in South African law, contempt can be prosecuted through motion proceedings. Sometimes Section 12 of the Constitution may require a full trial. Sometimes Section 35 of the Constitution may require a full trial. But that is a question of how to prosecute a contempt. It is not a question of whether in character, in essence, in substance, a contempt is different from any other form of a crime. That means then the only question to answer in this case is to go back to Section 47(1)(e). Was the second respondent convicted of an offense? Now, we know the answer to that question by looking at page 71. So, was the second respondent convicted of an offense? Now, page 71 contains the order, which is at paragraph 142 of the judgment. And paragraph 3 says, it is declared that Mr. Jacob Gedleyiselisa Zuma is guilty of the crime of contempt of court for failure to comply with the order made by this court. Now, declaring someone guilty of the crime of contempt is convicting them for the crime of contempt. Is crime of contempt an offense? I have already explained to the court that you have held so 4 times. You have no reason today to depart from it. So it is clear that Mr. Zuma was convicted of the offense of contempt. He falls within the controlling provision of Section 47(1)(e). The next question is, was Mr. Zuma sentenced to more than 15 months imprisonment? This too is answered at page 71. We go to paragraph 4 of the judgment that you gave. Mr. Jacob Gedleyiselisa Zuma is sentenced to undergo 15 months imprisonment. The third question, is the appeal proviso relevant? It is not, for the reasons I have tried to argue before the court. The last question, is the remission of sentence relevant or sentence reducing? The answer is no, it is not sentence reducing. So, in conclusion, the second respondent is disqualified from standing for the National Assembly. The IEC was correct to disqualify him. He is not disqualified by the IEC, he is disqualified by the Constitution. The Electoral Court was wrong to enable him to stand despite the fact that the Constitution disqualifies him. That is why the order of the Electoral Court should be set aside and replaced with the order dismissing the appeal. There is the final issue of the cross appeal. It is framed as a conditional cross appeal, but it is an irregular cross appeal and should be struck. That is because an appeal is only aimed at changing the order of the court below. We have referred to many judgments, Western Johannesburg Rand Board, Administrator Cape and Another versus Njotela. But the fact is that it is known that an appeal is aimed at changing the order of the court below. But the current cross appeal is not aimed at changing the order of the court below, but it is aimed at challenging and supplementing the reasons for the order. That means that it is not a competent appeal because it is an appeal against the reasons for judgment. And an appeal against the reasons for judgment is not a competent appeal. So you should strike the cross appeal and grant the appeal. Thank you, Deputy Chief Justice.
Thank you, Mr. Questions, please?
Mr. Mwaitot, can we have a look at the section? want to premise my question on the intention of the legislature.
You know, Justice Matopo, I once had a debate in this court with the then Deputy Chief Justice Museneke, and I kept saying to him, intention of the legislature, and then he kept on saying to me, no, Mr. Ngcukaitobi, it's the purpose of the legislature.
May I not borrow his word?
Yes, let's focus on intention. Yes.
Thank you. When the drafters of the section, as it is now, especially on the issue of the proviso.
Yes, the appeal proviso.
Yeah. Correct me if I'm wrong, that the section talks about two aspects which you've identified.
Yes.
The procedural as well as the substantive.
Yes.
The substantive being the disqualification and stuff like that.
Yes.
And the proviso being what happens.
Yes.
Yeah. Can it be said that it was the intention of the legislature that I don't want to say an accused person, it sounds too strong a word, a person who is sentenced to 12 months imprisonment would lose all his or her rights in terms of the proviso, number one. Number two, was it envisaged or contemplated that the Constitutional Court would sit as a court of first and last instance? Three, where it has said as a court of first and last instance, what happens to the rights of an accused person vis-a-vis his right to appeal? You have submitted that, and correctly so, that if a person has been sentenced in the magistrate court, he would have the right of appeal, stuff like that. And that sentence in the magistrate court will be given legitimacy and validity. But you said it is absurd of the electoral court to say the sentence in this court should not have the same force of law.
Yes, I'm happy to answer those.
Okay.
Thank you for the questions, Justice Matopo. Let me start with the second question. Was it contemplated that this court would sit as a court of first and last instance? The answer to that is yes, because the Constitution itself contemplates that a direct access application can be brought, and the case against Mr. Zuma was a direct access application. And there was no distinction that you can only bring a direct access application if there will be no punitive order granted. So the answer is yes, it was always contemplated that this court would sit as a court of first and last.
You would not mind if I interject and ask questions,
No.
especially on that one. If there is a direct access application in situations of this nature, can it, again, I go back to the intention of the legislature, can it be said that because it's a direct access application, the legislature intended that Mr. Zuma's rights to appeal, if not satisfied, would be taken away from him?
Yes, that's precisely the debate that was held in the rescission case, this entire discussion. And it's fully contained in the judgment of Justice Khampepe, that if the court is sitting as a court of first and last instance, there is no appeal. The reason Mr. Zuma sought rescission was because he said that he has no rights of appeal. Then the issue was debated, and then this court found by a strong majority that's the consequence of the decision that he made to defy the order of the Constitutional Court. So his rights to appeal were not denied. It was the interpretation of the Constitution that came into operation.
Sorry for the dialogue. It may be necessary just to clarify
Indeed.
what I have in mind.
Indeed.
So if direct access takes away his rights of appeal,
No, he has no right of appeal in a direct of access case.
against, right? But the section speaks about his rights of appeal. I have, or we would have, two contradicting, if I were to put it that way, provisions. One, it's a direct appeal, or direct access, so to speak, which this court regulates its own powers. And now we have the direct access, the section 47, which seeks to exclude him, exclude him. Let's put it, let me stop there.
Yes, let me answer that
Just
question.
if you can harmonize the two,
Yes,
if they need to be harmonized at all.
they don't need to be harmonized, but let me answer that. Let me take the question seriously. This is a proviso. So, by definition, a proviso does not detract from the controlling provision. It's subsidiary to the controlling provision. That's the first thing. The second is that it is a deeming provision. In other words, what it does is that it creates a fiction. See? Because what it says is that no one may be regarded as having been sentenced until an appeal. We know as a fact that you have been sentenced. We know as a matter of law you've been sentenced. But what the law does is then it creates this legal fiction that we will act as if you have not been sentenced. And it is not a section that confers a right of appeal. What it does, it creates the duration, a suspension of the operation of the disqualification until the right of appeal, which is not in the section, until the right of appeal is explored. So if you want to know where is the right of appeal, it's in section 35. This section does not give anyone any right of appeal. What it does is to suspend the execution of the sentence for purposes of section 47(1)(e) until the appeal process has lapsed or has been exhausted. So it's a fallacy, and it's a fallacy that runs through the judgment of the Electoral Court to say there is a clash of rights. There is a right conferred by section 47 and which clashes with the right conferred by section 19. There is no such.
Let me take it a step further. In the event somebody were to disobey this court, I mean the Constitutional Court, and that person's conduct were to amount to contempt, right? Would it be within the remit of this court to deal with him as it has dealt with Mr. Zuma, or would it fall within the remit of this court to convict the person because he would have disobeyed the Constitutional Court? Say, for example, something were to happen now. Yes. Somebody were to be disruptive, and that person disobey the sitting of this court, and then we would have to convict him.
Yes.
And then what do? Do we send him down or we sentence him?
No, you are entitled to sentence him. Mm-hmm. But once you have sentenced him, it becomes a final sentence. It can be executed immediately. It's no longer suspended by the suspension in 47(1)(e), because that suspension is to hold off the execution for an appeal, but you are a final court of appeal, so your sentence becomes operative immediately.
Perhaps it's a bad example. I think it's a bad example.
All right, let's see if we cannot get a better one.
Yeah. No, I will revert. Let my colleagues. Yeah, I will revert. I think it's a bad example.
All right, thank you, Justice Mutopo.
Mr. Ngokaichobi, my question is slightly different. The respondent has raised some issues or preliminary points, one of which is a question of urgency, why you bypassed the SCA, and the other one is that the matter is, the application is premature because the issue that's being raised should be determined by the National Assembly. Would you kindly deal with those issues?
Thank you. I mean that, Justice Mhlantla. Let me start with the urgency and the SCA. There are three reasons that are pleaded in the founding affidavit for urgency and exceptionality. The first is the need for finality. The applicant has excluded Mr. Zuma from the list of qualified candidates. Whether he is entitled to contest cannot be established after he has contested. That would be absurd. Finality on the question, therefore, of eligibility must be reached before the 29th of May, not after the 29th of May. The question is, should he be a candidate or not? And the public is entitled to know the answer before it votes. It cannot vote first and find out later that he should not have been a candidate. Secondly, there is a need to safeguard the integrity of the election. If a leader of a contesting political party is allowed to contest while the Constitution disqualifies him, as the second respondent wants to do, because that's what Mr. Zuma wants to do, that will undoubtedly poison the election and produce a disputed outcome. The country will therefore be sleepwalking into an unfree and unfair election, and the consequences will be grave for our own commitment to the rule of law and a commitment to our own Constitution. It will create the impression that we don't respect the rule of law and we are prepared to risk the legitimacy of our own electoral process. And then thirdly, the IEC says it has no practical relief beyond the 29th of May 2024 because the jurisdiction of the IEC is circumscribed to deciding qualification, working on a tight and a prescribed timetable. And therefore, if you don't decide the case before the 29th of May, for all intents and purposes, that will be the end of the road for the applicant. Because after the election, the IEC will cease having any legal interest in the dispute. And an appeal to the Supreme Court of Appeal now is simply not feasible, because the matter will simply become moot, and the second respondent will then have achieved what he seeks to achieve, which is to contest despite his disqualification. And then finally, on this point, you have dealt with a similar matter in principle, not on the facts, which was the case of Speaker of the National Assembly versus Public Protector. Incidentally, Justice Mhlantla, you wrote that judgment. And you will recall there that the same arguments, it's almost cut and paste, were made why you should not entertain the case. But in that case, you did not even have the strength of the facts you have here. You remember that the term of office of Advocate Mkhwebane was due to lapse in 2 years from the time the case was heard. It was not an election that is a few days away. And what did you do in that case? You entertained the direct appeal, despite the two objections of urgency and bypassing of the SCA. And why did you do so? We know your reasons are contained between paragraph 36 to 39. Firstly, you held that the appeal in that case was urgent, purely legal in nature, and concerned matters of public importance. This is precisely where we are. And secondly, you said that where there is a public interest and the fundamental principles of the Constitution are engaged, as well as fidelity to the rule of law, a matter should not be suspended in mid-air to take as long as it would take before it gets heard by this court, because that would not accord with the public interest and the finalization of important matters. You said that at paragraph 37. And then thirdly, you said it was necessary to save costs and time, particularly where the issue does not engage the development of the common law, but is a matter of crisp constitutional adjudication. And this is precisely where we are. And then fourthly, you said, well, we will look at the appeal when it bears prospects of success. No one can argue that this appeal doesn't bear any prospects of success. In fact, if you believe so, you must dismiss the case on the merits, not on direct appeal. And then finally, you said that you had heard the views of the full bench. In this case, you had the three views of the Electoral Court. They all diverge, but the fact is that you have the views of the specialist court. Our Constitution establishes this court as the specialist court in electoral matters. You had all of them. So we have our unique reasons that we have pleaded, and we rely squarely on public protector. And we say, when you look at the grounds on which you dispensed, when you were faced with the same arguments, you dispensed with urgency and dispensed with direct appeal. We fall full square on that authority.
Last question for now relates to the remission of sentence. I know that you said it's irrelevant, but it's one of the remission.
Remission, no, I didn't say remission is irrelevant. Remission is relevant because it's a ground on which we lost the case.
Okay.
Yes. What I said was irrelevant is the completion of sentence, 5 years after the sentence has been completed.
Mr. Mkatobi, I've been largely covered by my sister's questions, but I have one last one, also a preliminary point. The point is also made on behalf of the applicants that the Commission is not really seeking practical relief here. The applicants say that it really just concerns an individual's position, Mr. Zuma's position. In other words, they say this is a speculative exercise, and they invoke Ferreira versus Levine. What do you say about that submission?
It is a practical case. What has happened here is the IEC exercising statutory powers under Section 27 and Section 30 of the Electoral Act is obliged, it's not an option, it is obliged to determine eligibility of candidates. It received 22 objections in relation to Mr. Zuma. It upheld 2. Whether or not that decision was correct became the subject matter before the appeal court. The appeal court found against the IEC. The IEC believes that its original decision was correct. In other words, it correctly disqualified Mr. Zuma because he is disqualified by the Constitution. Now, it comes to the court to say that it wants you to reinstate its original disqualification decision. What will be the consequences of that? Those are set out at page 219, paragraph 70, 71, and 72. It will be able to remove Mr. Zuma as a contesting candidate. And this is a matter of immense constitutional importance because no one should contest for elections when the Constitution says they are disqualified.
Thank you. And lastly, just to confirm, I see in the papers that you're not asking for cost even if you're successful.
No, we are not. Yes, we've never asked for costs against the MK and Mr. Zuma.
Yeah, thank you.
Mr. Mugaitobi, perhaps my question is for you to please just explain for me what your submissions are really on this issue of the doctrine of separation of powers. Because you say that if a president grants remission or a pardon, that would amount to an encroachment of the power of the judiciary.
No.
What I need, okay, I'm happy you're not saying that, because I would then, my next question would be whether you are saying that separation of powers is absolute or not.
No, we don't say that. That's one of the problems with the Electoral Court's judgment.
I thought you were agreeing with the Electoral Court's judgment. Yes. On that score.
On remission, we don't say that the president has no power to grant remissions because that would violate the separation of powers. He does. The law allows him to do that. But the issue is whether or not, as a matter of law, a remission has the impact of reducing a sentence. We say that a remission does not have the impact of reducing a sentence for purposes of Section 47(1)(e). A remission has 2 consequences. One consequence is that it impacts the date on which you get released, which is what the Constitutional Assembly called execution of sentence. But when it comes to disqualification, remission is irrelevant, again, as contemplated by the Constitutional Assembly.
So your submission is contextualized.
Precisely. Thank you, Justice Chief,
I
for
needed
putting
you
it
to
that way.
clarify that.
Yes, no, it's excellent. Thank you for making that point. If I had created confusion, I apologize.
Mr. Nkaitobi, thank you very much for your submissions. I wanted to ask you a few points. The first that came up is the kind of question that we need to ask, because there's been some discussion, and you've referenced the travaux préparatoires, and it seems like almost you're making a claim that that because a particular interpretation is in the travaux préparatoires, that's something we should adopt. There was some discussion with my brother Matopa about the notion of the intention of the legislature, or the intention of the Constituent Assembly and drafters. My understanding is the approach in South Africa is not to adopt an original intent approach towards interpretation of constitutional provisions, and that the travaux préparatoires would only be relevant to the extent that it helps us understand the purpose of the provision as we're looking at the provision now. So I would like your submissions on that point about the interpretation and the way in which you're using those original documents.
Yes, we have referred to Makwanyane, paragraph 19, Mansing versus GCB, paragraph 27, and AMCO versus Anglo Gold, paragraph 57 to 61. So the first principle is that a travaux préparatoire is not a binding instrument on the court, but a travaux préparatoire is a useful source of understanding the purpose. But ultimately, you must decide what the purpose is. But what you need in order to decide what the purposes are the various sources. Source number one is the text. And source number two, maybe the history of the statute. And source number three, maybe the context of the statute in the rest of the Constitution itself. But the point I was making about the travaux préparatoire in this case is that when I read Makwanyane, Mansing, and AMCO, I found it striking that very few cases contain the direct question in issue, like the very question in issue. They are usually an indirect source where you have to still skip 2 or 3 stages before you get to the ultimate meaning. And the travaux préparatoire here is on the direct point we're debating today. When does the disqualification come in?
Thank you, but the key point is that what we've got to do is construct the purpose, not try and work out what the drafters were thinking at the time in relation to this provision, because that's an important question as to whether or not the drafters actually contemplated a sentence, for example, that was handed down by this court in the way it was, or it can go both ways, actually, in some ways. So, moving on, I wanted to ask you about the purpose. There's not so much that you say in your submissions. You talk about lawbreakers not being lawmakers, essentially, and it's left in that sense. Although, of course, some lawbreakers who fall under the 12-month provision can go to Parliament, right? So I want to understand from you a little bit more detail of how do you see the purpose of that provision, and particularly perhaps thinking a little bit about there's some political theory around the notion of defense of democracy. To what extent can democracy protect itself from harms that come from democratic procedures themselves?
Yes. No, you are right, Justice Bilches, in pointing to the incompleteness of our theorization on the purpose part, which is why we've tried to supplement the purposive argument by showing that it's not stopping lawmakers from becoming lawbreakers for its own sake. There are two additional purposes that are linked to that. The one is to look at the severity of the lawbreaking. So it's cutting off at 12 months. And the reason it's cutting off at 12 months, it's cutting off at 12 months to indicate that there has to be a degree of seriousness. There has to be a degree of heft to the law breaking. So not every law breaker. So if I break the law because I'm driving at 120 in a 60 zone area, I'm not disqualified from going to Parliament. So 12 months is an indicator of the seriousness. There's a second one as well, which is when we say it's a protective purpose, it's protecting the public. Right? There is a public interest in ensuring that the people that are going to be deciding what the law is are themselves compliant with the law. And but the threshold is it must be serious enough. You see? And then it's the third one, which is the institutional integrity of Parliament itself. That is what disqualification provisions do. Is they protect the institution to which you are disqualified, but they also protect the public from you and from the institution itself. Now, we found this, I don't want to claim being the original, but we found this from the report on exclusion of offenders from Parliament of the 23rd of November 2018. And we've referred to that, and it's a useful source to explain why countries everywhere in the world have disqualification provisions that are linked to criminal behavior.
Thank you. So I wanted to proceed on the question of harmonization. Some of the international law, comparative law that we've been referred to, clearly recognizes that that disqualification provisions limit political rights of a kind. The Harvey case, the Paxos case, and various others that we have been referred to. We now need to interpret Section 47 and harmonize it in some way with other provisions in the Bill of Rights, with Section 19 and the right to appeal in criminal matters in Section 35. Why would a restrictive interpretation to disqualification as to only take place where an appeal is available, as is contended for by the respondents, not provide a more harmonious interpretation of these provisions with one another? In other words, why should we not interpret in favor of participation and so adopt a more restrictive interpretation of Section 47?
Yes, let me just start with the two premises of the question. The premise one is that there is a tension, and the reason the tension is mentioned is because of judgments like Harvey. South Africa is not there with any tension, because if the disqualification had been contained in an act of Parliament, a law of general application, then an issue would arise between, there is a tension between a general right and an act of Parliament. That does not arise in this case, because what has happened is that these are so serious that they have been included in the Constitution itself, which means then you go back to UDM, which tells you that there is no tension. The first principle is both sections must be given full effect. One does not take priority over the other. So this is why we say the matter is actually straightforward. Section 19 applies to people who are not disqualified, and it is not a question of restricting rights. I don't know the law under which the Harvey judgment was decided. I don't know the structure of their constitution. What I do know is South African law and the structure of the South African Constitution. There is no tension, there's no need for harmonization. So
I'm not sure I agree with you on that, because not because, as you correctly say, many of those countries were interpreting a sub-constitutional law. So that's correct. But in cases where our law, for example, we're having to construct Section 47, and the argument is that there's some ambiguity as to which kind of sentence or conviction it applies to, shouldn't we then recognize that there would be a restriction on someone disqualified from standing, the Section 19 rights, and therefore try and interpret Section 47 in as restrictive a way as possible?
No, it's an impossible proposition. Firstly, for what I say, which is Section 47 is a constitutional provision. It's not a subsidiary legislation provision. And if you are dealing with a constitutional provision, you must give effect to it in full. It's not limiting anything because it cannot limit itself. You will be distorting the law if you took that approach. If you are to give effect to Section 47, you must give effect to its own purposes. It is a constitutional goal to restrict people that have broken the law in a serious way from becoming lawmakers. That is a constitutional goal. It is not a goal that somehow Parliament decided to insert, but it is a goal that was decided upon us by the people that drafted the Constitution. So that itself needs to be given effect. But it's also an absurd thing because that Section 47(1)(e) also 47(1) also contains unrehabilitated insolvents. It also contains people that have been declared to be of unsound mind. So the moment you start saying my premise is Section 19, you always get into the risk that what you ultimately find, you find an unworkable Section 47, because what you do, you just debase it. You make it a free-for-all. And that is why we insist that if you are serious about the rule of law, you have to give Section 47 its full meaning.
Thank you, Mr. Rapporteur.
Thank you, Justice Beatrice.
Thank you, Mr. Ngwetop.
Thank you, Deputy Chief Justice.
Oh, sorry. It turns out that Justice Theron has questions for you.
Apologies.
Mr. Mugaito, we can refer you to paragraph 51 of the Electoral Court judgment, please.
Okay, which page of the record? Or 51 page of the record? All right, thank you. Page.
Do you have a copy?
Sorry, Justice Theron, I need to find the judgment of the Electoral Court. Do you have the reference in the record? 400. Or 400?
Volume 5.
400, yes.
Thank you, my sister.
Your juniors must earn their keep, Mr. Ngwetop.
So they've now resorted to giving me their own computer. Yes, I am at page 400.
Yes. Do you take issue with the first sentence in paragraph 51? The drafters of the Constitution recognize the fact that a person convicted and sentenced has a right of appeal against their conviction and sentence upon leave being granted by the trial court or if refused on petition to the Superior Court.
No.
Do you take issue with the second sentence? If that fact was not important to them, they would not have inserted the proviso which seeks to preserve the status quo pending the appeal processes.
No, we don't. I mean, we've said so in our main submissions.
In other words, they refer to conviction and sentence. I would say, in other words, the disqualification does not take effect until the appeal process has taken place. Alternatively, a convicted person or sentenced person has elected not to appeal.
Yes, we've said so. We agree with that.
So, when courts interpret legislation, they must assume that the legislation must be taken to know the law. Is that right?
Yes.
Now, when we interpret Section 47, must we assume that the legislature, when it drafted that section, knew that in terms of our law then, at the time of drafting, every accused person has a right of appeal, subject to leave being granted?
Yes, but they would have known two things. One is that in a criminal trial under Section 35, there are rights because they have drafted them. They would also know a second thing, that there is also the right of direct access because they drafted it. All of this is in the same document.
They would also have known that direct access, which is a procedural provision regarding which forum you can take your matter to, would not trump any other provision in the Constitution. That's what the drafters would have known.
Well,
and you made that submission a few minutes ago. You said where there is tension between provisions in the Constitution, both provisions must be given full effect. So the drafters of the Constitution must be taken to have known that.
No, Justice Saron, the drafters of the Constitution knew two things. They knew that there's Section 35 because they drafted Section 35. They knew there's Section 167, they drafted Section 167. They knew that it is a procedure, but they knew that if this court makes a final judgment, it becomes a final judgment. So you can't now just write out the other section.
Yes, but the drafters also knew that fundamental rights will not be taken away.
But Justice Saron, you've had that debate already with your colleagues twice. The debate about Section 35 and Section 12. This is not the case to have that relitigated again. That debate has been had. Whether or not a direct access case should result in the imposition of an imprisonment sentence was precisely the point at which you and Justice Khampembe disagreed. So this is not the case to relive that experience.
What we are doing, Mr. Magatobi, is to interpret Section 47 in the context of the law. Your earlier submission was that legislation must be interpreted having regard to the context.
No, I'm saying
what I am suggesting is that an important contextual factor in interpreting Section 47 is the fact that the legislature was aware of the right to appeal, which is a fundamental right. The legislature was aware that every convicted person would have a right to appeal. The legislature was aware that rights would not be taken away unless that was by specific design.
Yes, but
the legislature was aware that different provisions of the Constitution, where there's possible tension, would be read in order to give effect to both provisions. So if there's a tension between 167 and 35 or any other provision, the legislature was aware that both provisions would be given effect to, as you submitted a few minutes ago. And my concern is that we must apply the law equally and the same in every matter. All principles of interpretation as well should be the same. It shouldn't be said that, like I said a few minutes ago, you said where there's two conflicting or two provisions that have tension, both provisions must be given the full effect. So we can't do that in one case and not in another.
But Justice Saron, you've had this same debate because I've been in this court twice on the same case. This is the view you expressed in the previous two cases. The majority judgment found that it was not taking away any rights. So if you want to interpret Section 47(1)(e), you must take seriously the judgments of the Constitutional Court. This very point that you put into me, we've debated it twice. The fact of the matter is that the majority judgment found that merely finding Mr. Zuma in contempt and sending him to prison did not violate any rights in the Constitution of Mr. Zuma. This is an express finding of Justice Khampembe. She said so in the contempt, she said so in the rescission. So now this is a third time where the issue is being resurrected again. And now it's under the new vehicle of Section 47. So we referred to this in our heads of argument at paragraph 43, where we quote specifically what Justice Khampembe said, where she says the Constitution categorically allows the denial of the right of appeal by empowering this court to entertain matters by way of direct access. And that is at paragraph 79 of the judgment. So this debate has been had and it's been settled by a majority judgment.
Yes, and that is why I don't understand your submission, Mr. Mugaitobi, when you say no rights have been taken away, because the very passage that you refer to says that the Constitution allows the denial of a right.
But that's not unlawful.
And a few minutes ago, you said no right has been taken away, and you said that was found, that's what the majority judgment found.
But it's not unlawful. This is the point, because they said it's lawful, it's permitted under the Constitution. So that's not unlawful. So there's nothing wrong in that finding. It's a binding finding of the court. Now, you cannot say, I want to interpret Section 47(1)(e). In order to do that, I must undermine the majority judgment. That itself is a violation of the rule of law.
When this court interprets Section 47, must it have regard to the context that when Section 47 was written, the context was that every accused person had a right of appeal?
Justice Theron, we've debated that 10 minutes ago, and I have said twice that it also knew that there is a direct access provision, and it also knew that when the direct access provision is engaged, the outcome is that you have no right of appeal, because this court is a final court of appeal.
Now, apart from the Zuma contempt judgment, where that principle emerged from, is there any other authority for that proposition or principle?
No, the Zuma contempt judgment is the binding authority. That's why we refer to it.
Yes, my question is there any other authority?
No, I submit, Justice Theron, there is no need for us to find other authority, because you have a binding authority which is recent.
Let me finish my question, please.
All right, I apologize.
Apart from the Zuma contempt judgment, where that principle emerges from, is there any other authority in support of that?
No, we don't rely on any other authority. We rely on the Zuma contempt judgment. We say it is binding, it's recent, you should follow it.
My question was not what you are relying upon, Mr. Mugaitobi. My question was, apart from that judgment, is there any other authority?
Nothing that we have found, but we say, and this is my submission, you are bound by the judgment. You can't undermine it because you're undermining your own judgments.
Now, if we look at Section 47, it does not say that in some instances the proviso will not apply. And I understand that to be what the applicant is arguing, that in this case, in the facts of this case, the proviso doesn't come into operation.
Yes, what we say about the proviso, thank you for that question, and hopefully we can go back to the proviso. What we say about the proviso are three things. Firstly, it's a deeming proviso, and a deeming proviso from Chotabai is that it deems things to be what they are not. Secondly, we say a proviso cannot undermine the controlling section. In order to know the full meaning of the section, you've got to look at the controlling section. And thirdly, we say its purpose is to allow an appeal to take place. But once this judgment was granted by this court, that purpose was fulfilled because this court acted as a court of first and last instance.
If we look again at the Electoral Court judgment, paragraph 50.
Same page. Yes, I'm there.
The third sentence.
Third sentence of what?
Paragraph 50.
Yes, I've got that.
Justice Zondi says, this construction which the Commission seeks requires the courts to read in words into Section 47(1)(e), the effect of which will be to exclude the operation of the proviso in section 47(1)(e) if a person concerned was sentenced by the highest court in the land. What do you say about that?
No, it's wrong, because the effect of what we're contending for is simply this. If a judgment has been given by this court acting under section 167 as a court of first and final instance, the object of the section, which is finality, has been achieved.
If the legislature envisaged that there would be a class of persons against which the proviso would not apply, shouldn't they have said so?
There is no class of persons from which the proviso doesn't apply. It applies to everyone, including those persons that have been sentenced by the Constitutional Court. It's the other interpretation that creates the arbitrary distinction.
What does the word until mean in the proviso?
Well, it's obvious what it means. It means it's to open up the possibility that the appeal must be finalized, but that possibility has been exhausted once you have made the decision.
Well, it hasn't been exhausted. It wasn't granted. There was no possibility of appeal.
Yes, but
so the proviso never kicks in.
But that's the consequence of the fact that you exercise original power and you exercise direct access power. So what that means is that finality, the section is there to preserve finality, but finality is achieved as soon as this court makes a decision.
On the assumption that Section 47, that the drafters of Section 47 had in mind that every convicted person in sentence has a right of appeal, subject to leave being granted. Let's leave out the possibility of being sentenced by this court with no possibility of appeal. What possible interpretations would there be to Section 47?
No, but even on that construct, sorry, Justice.
I think, Mr. Mugatobi, I've been watching for a while, keeping quiet. It might be helpful just to tone down a little bit. You come across as being very irritated and impatient with Justice Theron, and it's not seemly. Just relax and let her finish her questions. You're not going to get questions you like all the time. Just answer the question,
I apologize, Deputy Chief Justice. Sorry, Justice Theron, I should be apologizing to you.
Mr. Mugatobi, I know you mean no offense,
yes,
I take now.
Yeah, no.
We have walked a little way together.
Yes, no, I know. Yes.
Okay. On the assumption that the drafters of Section 47 had in mind that every convicted and sentenced person would have been afforded a right of appeal. Where a person has not been afforded a right of appeal, what options would be open to this court as to how to interpret Section 47(1)?
I was saying, even on that construct, even on the construct you have given, you still have the possibility that a criminal trial takes place in the magistrate's court, takes place in the high court. This court decides that the sentence is too lenient and it imposes an original sentence. You still come back to that point. If they are correct at the electoral court level, that means you strike out the entire Section 47(1)(e).
Sorry, I only heard the last part where you said, if that, and then I missed some words, you said, strike out the last part of 47(1)(e).
No, I'm saying that even on that construct, in other words, a construct in which we have a full trial before the magistrate's court, and a full appeal before the high court, and a full appeal before the Supreme Court of Appeal, you still have the possibility that this court has the power to impose its own sentence if it believes that the sentence originally imposed is too lenient. So you come back to where we started, which is there is no way in which you can interpret that section as excluding sentences imposed by the Constitutional Court.
But that would be an appeal, that would be a sentence altered on appeal. It would not be a sentence as an original sentence. While we're on that,
increased sentence.
The magistrate's court gets its penal jurisdiction from the Magistrates Court Act. The High Court gets its penal jurisdiction from the Superior Courts Act. As I understand, the Supreme Court of Appeal does not have penal jurisdiction. Where does the Constitutional Court get penal jurisdiction from to impose a sentence as a court of first instance?
Well, you've exercised that power because you were exercising original constitutional jurisdiction, and you imposed it in the context of Mr. Zuma, the same as exercising the power as an appeal court. The Supreme Court of Appeal has done so several times, and we can refer the court to its many judgments where it increases the sentence as opposed to examining the sentence imposed by the lower court as a court of appeal. So the law is clear that even the Court of Appeal have penal powers.
Yes. I'm not dealing with the powers of a court of appeal or the powers of a court hearing an appeal, to the power to decrease or to increase a sentence. Talking about a power to impose an original sentence and the penal jurisdiction that grants the court that power.
Yes, but Justice
And if I understood your answer was that this court would derive that source of power from its constitutional jurisdiction.
Yes, I'm saying the Constitutional Court derives original sentencing power from the Constitution itself. It has exercised it in the Zuma case.
And does this arise from the direct access provisions?
Yes.
And so you say from the direct access provisions, this court derives original penal jurisdiction?
Yes, but it also derives it from Section 172, just an equitable remedy, where it has found that the Constitution has been violated. And in the case of Mr. Zuma, it was a direct access provision, and it had found that its own judgment was violated, its own authority, its own standing was threatened, and it exercised original constitutional jurisdiction. In fact, if you look at if you look at that page 71 I was referring to earlier, it's page 71, not paragraph 71. If you look at the order itself, it's at page 70, paragraph 71. It was a declaration, paragraph 3. It is declared that Mr. Zuma is guilty of the crime of contempt. And then Mr. Zuma is sentenced to undergo 15 months imprisonment. So the court did exercise original sentencing power.
If I can take you to the Sibia case.
Sibia.
Yes.
I'll have to find it, I'm afraid. Anyway, let's hear what the substance of the issue is.
The respondents rely on the following passage from that case. I think it's at paragraphs 40 to 43. It says, the president does not determine the sentence, but merely imposes it. And then a few lines down, it says, the president substitutes the sentence recommended by the judge in a situation where the person whose sentence is
Sorry, Justice Aaron, where are you reading? I'm sorry to stop you, but I don't follow where you are reading from. Which paragraph?
It's a paragraph that's quoted in the respondent's heads at page 120.
All right. Which paragraph of Sibia? I've got Sibia in front of me.
Can I refer
It's 41.
Yeah, yes.
Yes, it's paragraph 41.
Yes. The president substitutes the sentence recommended by the judge in a situation where the person whose sentence is substituted has already been tried, convicted, and sentenced, a person in respect of whom the judicial process is over. And I suppose the applicant would support that position regarding remission.
Sorry, Justice Saron, you'll have to put that again because I've just looked at the facts of that case. It was a case about substitution of death sentences. So, which has nothing to do with the power of remission.
The respondents rely on it in respect of the doctrine of separation of powers.
Justice Saron, we don't take issue with the doctrine of separation of powers. What we say is that if you apply the remission, because Mr. Zuma did not get a commutal of sentence, you'll see in that judgment, it's paragraph 18. It's a substitution of a sentence of death. And historically, it has always been acknowledged that the president, as head of the executive, is entitled to commute a death sentence to a sentence of life imprisonment. That has nothing to do with a remission, which is what the case is about. This case is about a remission. The question for a remission is a narrower question, which is whether or not the effect of a remission is to amend the original sentence. And the problem here, Justice Saron, that's probably a good thing you've raised this point. The problem here is that you have the electoral court finding that the sentence was 3 months. And it makes that finding without any textual support, either in the judgment of this court or even in the decision on remission. It imposes its own sentence retrospectively. And then, that's number one, the clear distinction. And then you look at what is the law on remission. The law on remission is the remission simply impacts the duration of the sentence to be executed. It does not impact the original sentence. What is the position on section 47(1)(e)? 47(1)(e) is clear. It is not about the original sentence. It is about the original sentence. It is not about the execution of the sentence. So I'm afraid Sibia is irrelevant.
The respondents say that, or they criticize the applicant. They say section 47(1)(e) is concerned with the length of sentence imposed. Just a minute. It criticizes the IEC. It says that the IEC does not provide any authority for the submission, that section 47 is concerned with the length of sentence imposed and not sentence served.
Well, we have dealt with this at length. Firstly, we have said it's the text, because the text says sentenced. It does not say sentence served. Number two, we've said it's the object behind the text. Who sentences? It is only a judge that can sentence. Whatever the president does about a remission, he cannot sentence. He can always impact the length of the sentence to be served. But what he can never do, he can never sentence. Section 47(1)(e) is about who sentences, and only the court sentences. And then we have drawn the court's attention to what the drafters of the Constitution thought about remissions.
I may be wrong, but it seems to me that both the applicant and the respondents rely on Smith and Boshego.
We don't rely on Smith and Boshego. We just say that they've been incorrectly invoked.
Do you say they're not applicable in this matter?
Yes, they are inapplicable because those judgments were about parole. This is not a case about parole. In fact, Mr. Zuma disavowed parole. We have no problem that a remission has the natural effect of reducing the sentence that you serve. I mean, that is clear. You get out of jail. The issue is, we say that parole does not affect the original sentence. Section 47(1)(e) is about the original sentence.
Thank you, Mr. Manitoba.
Thank you, Justice Saron.
Any questions? Or you want a second bite at that?
Justice Matopo finally came back to the question he had for me.
Mr. Ngogaitobi, I want to take you back to the judgment of the Electoral Court, in particular, the paragraph 51, that, no, you don't have to go there, I'll read it out.
Okay, yes, thank you.
The pronouncement by Zondi, and I want you to contrast that with the judgment of this court by Kampepeji. Zondi, in the last but 3 paragraphs, says, in my view, the sentence that was imposed on Mr. Zuma cannot be said to be a sentence which...
Justice Matopo, you are at 50.
51.
51, okay,
51.
yes, that's one.
Just before the order.
Yes, I got that.
It says the sentence cannot be regarded as a sentence which the section contemplates.
Yes.
We know that the Concord sentenced Mr. Zuma to a period of imprisonment.
Yes.
I'm just worried about the nomenclature there. If the Concord said he's sentenced to that period, and the Electoral Court judgment is that he was not sentenced, please assist me to understand the two.
No, I mean, on the one hand, Justice Matopo, I could take the opportunistic view and say that, look, they're obviously undermining the authority of the court. But I mean, there is a construct to what they're trying to say. They're trying to say that Section 47(1) does not apply to sentences which do not contemplate an appeal. I think that's what they're trying to say. And then the presentation could be a clumsy presentation, but they're trying to draw this distinction, which we say, as a matter of law, is wrong. But that's what we interpreted what they are saying.
Okay, this would be the fundament of its case.
Yes.
If it falls on that pillar then there would be a problem.
Yes, we say that it's illogical, it doesn't make sense, it's contrary to the text, it's contrary to the purpose. But it would be the heart of it. What they're trying to say is this section does not apply to sentences where no appeal is provided for. That's what they're trying to say.
Would I be correct to say there are only 2 operative words? It's sentence and remission that forms the core of this case. Sentence as espoused by Zondi.
Yes.
The remission as propagated or propounded by Justice Mudiba.
Mudiba. Yes. Those are the 2 issues on appeal.
Let me take you to paragraph 78 of the same judgment, but it's a judgment of Mudiba. It says here, in my view, on the date it was granted, that is the remission reduced Mr. Zuma's effective sentence. As a result, the legal effect of a remission reducing the sentence absolved Mr. Zuma from the legal consequences of the sentence imposed by the Constitutional Court.
Yes.
This is one of the main arguments by the respondents. And I just want to have your view pertinently on this. I know you've said that the remission does not alter the sentence. The sentence remains as is. They seem to have relied on the fact that it reduces, and they've relied on a biblical text, which Mr. Mpofu will address us in the fullness of time. Amen. To the effect that if your sins are remitted, you are more like as clean as nothing has ever happened.
There is a world in which
that analogy be applicable here?
No, the analogy simply does not apply. We've said, again, based on the text of the section, based on the travaux préparatoire, and also based on the purpose of the section. because the section's purpose is to be aligned with what the judiciary considered to be serious enough to impose a sentence beyond 12 months.
Well, I'm trying to visualize a situation wherein a court of law has imposed a particular sentence to an offender, and an executive sitting somewhere decides to expunge that sentence. And is it permissible?
Yes, if you exercise...
No, not expunge. I use the word wrongly.
Yes.
Yeah, the executive decide to remit or, yeah.
Yes, I mean, this is what the president did. They remitted the sentences. But what became the consequence of that? Did it have the effect that it nullified the sentences imposed by judges? That's the heart of the problem. We say it could not have that effect to nullify the sentences imposed by the judgments.
Would that not implicate the separation of powers principle?
It would, if the effect of a remission would be to nullify the judgments imposed by the judges. But we've tried to say before the Constitutional Court that there is a narrower interpretation to this, which does not engage separation of powers concerns, which is simply that if you look at the text, does the text contain exclusions on remissions, yes or no? No. If you look at the travaux préparatoires, what did they think about the remissions? They thought that the remissions would not impact on the original sentence. If you look at the object is to indicate exclusions based on the seriousness of the sentences imposed by the judges. That, we've said, is enough to dispose of the case.
I seem to recall that in one of the judgments, and most certainly not Zondi, it may be Mudiba or Yakub, to say if the president acts as he did, interfering with the sentence, that intrusion is lawful.
Yes, what they did, they looked at, Justice Mudiba looked at the certification case, which dealt with pardons. There is a line in that judgment that says a pardon power has always been the power of the head of state, which we have no difficulty with. But she conflated that with remissions. And this case is not about a pardon power, this is a remission case. A remission has always stood in a different category to remissions, to pardons. It has always been, we just release you. In this case, it was because of overcrowding in prisons. That's the at least ostensible ground. But it has never been a remission expunges.
McBride case, he was granted amnesty.
It was an amnesty case under the TRC provisions, yes.
Right. And where would he fall in the bigger scheme of things?
Well, amnesty
in the
was,
context of this case?
Yes, no, amnesty was a specific thing. In fact, this case recently decided an amnesty case in the context of special pensions. But amnesty was I suppose you could say it was a form of pardon. But amnesty was a specific thing during the transition, which was created by law, that there will be certain prisoners or certain offenders who would be given amnesty if they complied with certain requirements. And what were the consequences? I mean, Mr. McBride was then called a murderer, and he was very upset about that. And we came to the Constitutional Court saying, well, I've been terribly defamed. And what was the outcome? The outcome was that you may have received an amnesty, but it doesn't change the fact that you were convicted and sentenced for murder.
Okay, finally for me, if Mr. Zuma had been granted pardon, you wouldn't be here. Or
yes,
would you be here?
Yes, we looked at that. We think that pardon would have probably placed him in a different category. If you look at those travaux préparatoires that we've relied upon, they specifically said that a pardon has the effect of expunging of conviction and sentence. And then they said, but a remission doesn't have that effect. If the president had pardoned him...
So the short answer is we wouldn't be having this debate?
Yes, probably, because it would have created this legal fiction that let's act as if he had not been sentenced, and let's act as if he had not been convicted.
Okay, thanks.
So, Toby, just a quick follow-up on McBride. When you read that judgment, it's clear that this court agreed with the minority judgment of Mtiane J.A. And it does describe the case of pardon as pardon because the amnesty provisions makes provision for the conviction or any civil debt to be completely obliterated, and it uses the words expungement throughout.
Yes.
So it's clearly an expungement case, just to be clear.
No, it's indeed. That was the thing, is that it's expunged. It's a fiction, treated as if it never happened. But that fiction doesn't apply to remissions.
Yeah, thank you.
Can I just put just one last one?
Okay.
Just one.
Justice Matopo, don't ask me, ask the Deputy Chief Justice.
Well,
so.
I've got that permission.
Yes.
Let me put it this way. Whether I like it or I don't, the Kampepe judgment is binding on me. Whether I want to put my different interpretation as far as I want to stretch it, there's nothing that I can do. I must respect it because of the starity cases.
Yes, Justice Taron.
No, I'm asking you.
Yes, Justice Matopo, that's correct. No, I'm just pulling Justice Taron's leg because it was on this point that we started quibbling.
Okay.
Yes, but the answer is, the serious answer is that's correct. You're bound by the judgment.
Until it is set aside.
And this would not be the
set
forum.
aside by the minority judgment. Hopefully one day it will be overturned, but at the moment it's binding. Sorry, Justice Matopo, did I interrupt you? Oh, thank you.
Thank you, Mr. Matopo.
Thank you, Deputy Chief Justice. I'm indebted to the court.
Mr. Ferreira? And yet, Mr. You really hurry.
I'm sorry.
There are still three amici to make representations. Mr. Ferreira, it appears that there's a tussle about time between you and Mr. Du Plessis. It's 10 minutes per amicus. So if he indicated that he may want 11 minutes, if that's going to be the case, you have 9 minutes. So let's be clear on that.
Thank you, Deputy Chief Justice. I will endeavour to be brief, and I will not traverse material which Mr. Nkokaitobi has already covered. Justices, if I may divide my submissions into what it looks like the two primary issues which are detaining the court in the debate today. First, the meaning of section 47, the meaning, I'll wait until the video games have calmed down.
Sit down. You can sit down. Let's go back.
Thank you, Deputy Chief Justice. Deputy Chief Justice, I understood, as I act for two amici, I was entitled to both of their time, subject to some of that going to Mr. Du Plessis if I finish in time. Was that a misunderstanding?
No, there seems to have been a misunderstanding. It's 10 minutes per amicus.
Correct, and I act for KSAC and...
Oh, sorry. Oh, you have two.
I have two.
I'm sorry.
Because Ms. Hassamesi and Ms. Leroux are not here, I am for both KSAC and the Kathrada Foundation.
In a long day.
Thank you, Deputy Chief Justice. Even though I act for two amici, I will endeavour not to cover any of the ground which the main applicant has already covered. There are simply a few additional supplementary submissions The first under the heading of the effect of remission of sentence on whether Section 47(1)(e) applies, and the second under the proper interpretation of the proviso to Section 47(1)(e). If I may start immediately with the question of the effect of a remission, our submission, Justices, is that in law, the effect of President Ramaphosa's remission of former President Zuma's sentence was merely to constitute an effective reduction of the time that had to be served of that sentence. It is helpfully contrasted with the legal consequence of a pardon, which does something different. A pardon reaches back in time and changes the legal consequence of that conviction and sentence and effectively expunges it. So once there's a pardon, as we understand the law, it is as if there never was any sentence or conviction for all purposes in law. That this court made clear in the Masemola case, at paragraph 37, where the court made clear that the effect of the pardon was to expunge the criminal record in every respect. We submit that a remission of sentence is quite different. It does not have the effect of expunging the legal consequences of the conviction and sentence. It is only about the practical question of how much time must this convicted and sentenced person remain in prison in service of that sentence. And one can see that that difference in function arises from the different kinds of reasons why there are remissions and pardons. So, for example, in this case, there was a mass remission of some 9,000 sentences. And the reason was due to practical consequences of the COVID pandemic on the management of our prisons. It didn't mean that those people were never sentenced or convicted for those crimes as a matter of law. It just meant that there was a good practical reason, perfectly lawful, for letting 9,000 people out of prison before the conclusion of their sentence. And that simply has no bearing on the question of whether they were convicted or sentenced in the first place. When you apply that conceptual distinction to Section 47(1)(e) and adopt a purposive interpretation, it makes very clear that a remission could never have the consequence of rendering the sentence determined in the substantive part of Section 47(1)(e) inapplicable. And the reason why is that the purpose of Section 47(1)(e) in calibrating this disqualification to a particular sentence was to link the question of eligibility to the gravity of the crime that had been committed. It doesn't say everyone convicted of any sentence without the option of an unsuspended sentence without the option of a fine is ineligible. I had a look before the hearing started at other statutes which impose ineligibilities on the basis of criminal conviction. And there are a lot of them on our statute books. For example, in the Companies Act, you're precluded from being a director if you are convicted of a crime which has an element of dishonesty. But very few of those disqualifications include the length of the time that you are sentenced to as an element of it. Most of them simply disqualify you if you are convicted of an offense that is not suspended. The difference, we submit, is that Section 47(1)(e) recognizes that ineligibility to stand for election to the National Assembly is a very serious ineligibility. It is something that should not be imposed lightly, and it is something which the drafters of the Constitution, in their wisdom, decided should be imposed in proportion to the seriousness of the criminal offense which has been convicted. And they decided that those who've been convicted and sentenced to a period of more than 1 year, that is where that calibration, the link between the gravity of the crime and the ineligibility comes in. Now, a remission, unlike a pardon, simply has no impact on the gravity of a criminal offence in law. It's about the practical question of must this person remain behind bars and how long, and should we let them out because we're having a problem managing our prisons. A pardon, by contrast, has the consequence that our law recognizes that that offence should no longer be deemed to have that gravity, and as a result we say it stands on quite a different footing. And one can see, if the approach of the Electoral Court was upheld, for example, that one would have very serious difficulties of certainty and predictability of knowing which prisoners are ineligible for which positions, because all of the 9,000, for example, prisoners whose sentences were remitted at the same time as President Zuma's, there would then have to be a debate about, does this remittal reduce their sentence to the point where it goes below 12 months? It depends on the original sentence. It depends on how long the remittal was in relation to that sentence. There is then going to be significant uncertainty around the question of when this lack of capacity operates. By the way, the only provision I could find which mirrors the language of Section 47(1)(e) was that in order to be a human rights commissioner, one also must not be convicted of a sentence and sentenced to more than 12 months. So that is what we say the purpose of the substantive disqualification is. The IEC has already submitted that that is exactly what the drafters of the Constitution said when they were drafting the Constitution, and that material has been placed before you. In the heads of argument of CASAC at paragraph 35, we set that out in more detail, and it is certainly an important guide to interpretation, although, Justice Bilschitz, we accept not binding upon the court. And more importantly, what CASAC adds to this debate is that it is exactly what the Indian Supreme Court decided in the decision which we have referred to, and which I will, I'm sure, butcher the pronunciation of, Sarat Chandra Rabha. It's a decision of the Indian Supreme Court, and what is remarkable about that decision is that it is how remarkably similar the facts and the legal issues, and even the very language of the constitutional disqualification that that court were considering. One might even be tempted to think that the drafters of our Constitution took inspiration from the Indian Constitution in drafting its disqualification provision, because when you read that judgment, and it's quite a short judgment, we would commend it to the court, it is on all fours with the issue that is being debated before this court. There's simply no difference at all. In that matter, there was a very popular politician who was convicted of a crime. He was sentenced to a sentence of 3 years. In the Indian Constitution, one was disqualified from being eligible for their parliament if one was sentenced to a crime of more than 2 years without the option of a fine. And exactly as here, he served part of his sentence, and then there was a remission of that sentence. And the question which the Indian Supreme Court debated and decided in that matter was the effect of that remission to change the sentence for the purpose of the disqualification provision. And it held absolutely clearly at page 5 of that decision that the effect of an order, though the effect of an order of remission is to wipe out that part of the sentence of imprisonment which has not been served, and thus in practice to reduce the sentence to the period already undergone, in law, the order of the remission merely means that the rest of the sentence need not be undergone, leaving the order of conviction by the court and the sentence passed by it untouched. In this view of the matter, the order of remission passed, in this case, though it had the effect that the appellant was released from jail before he served the full sentence, did not in any way affect the order of conviction and sentence passed by the court, which remained as it was. And so we submit that Indian case, unlike many of the cases which are referred to by the respondents, which relate to tangential issues, and yes, they mention remission, are not really on all fours. That case is exactly on all fours with this case. Justices, those are our submissions in relation to remission. In relation to the proper interpretation of section 47(1)(e), we submit that one must start with the text of the provision, and we have made a distinction between what we call the substantive and the procedural part of that section. And what we submit is that the substantive part, in other words, the part of the section which imposes a disqualification or takes away a right, is the section which determines who becomes ineligible. That's the part which says anyone who is convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine, etc. That's the substantive part. The proviso provides for something different. It provides only for a question of timing. It says, when is the substantive disqualification to become operative? The time at which that is to occur is when either the appeal has been determined, we know that doesn't apply in this case, or until the time for an appeal has expired. Now, our first submission is just on the plain language of that case. In relation to a sentence and conviction imposed by this court, the time for what is the time at which the time for an appeal has expired? It is as soon as the sentence and conviction is handed down, because there's no conviction. So the question, when, is answered by immediately. And so one doesn't even have to get into the fancy interpretive steps, because there is no time for an appeal in respect of a sentence and conviction by this court. Then you take that together with the authority of the appellate division in Mposi, which we referred to in the heads on behalf of the Kathrada Foundation at paragraph 18. What is made clear is that in general, when you're looking at a proviso like this, the courts are not willing to let the tail wag the dog. The proviso cannot purport to alter the content of the substantive enactment. And that authority was approved by the Supreme Court of Appeal in Endumeni. But we would just commend to the court the dictum at Mposi in paragraph 18.2 of our heads, and the court there warned about the fallacy of the proposed method of interpretation, which treats a proviso as an independent enacting clause, which sins against the fundamental rule of construction that a proviso must be considered in relation to the principal matter to which it stands as a proviso. It treats it as if it were an independent enacting clause instead of being dependent on the main enactment. So when you take those interpretive injunctions in mind and you look at this provision, you look at the purpose as a whole. The purpose is to say when there is a criminal conviction of a certain gravity of seriousness, that person becomes ineligible to be a member of our National Assembly. When does that ineligibility operate? The purpose of the proviso is to secure finality. It does not, and it seemed to us with respect, that some of the questions posed to our learned friends for the Electoral Commission treat the proviso to Section 47 as if it confers a right of appeal. Section 47(1)(e) does not give a right of appeal. Section 47(1)(e) only determines when the disqualification becomes operative or final. Rights of appeal from criminal convictions are determined by other provisions, both in the Constitution and the Criminal Procedure Act, but Section 47(1)(e) on its face and on any proper interpretation does not purport to give anyone any right of appeal or any substantive protection. All that it determines is the time at which the substantive ineligibility becomes operable. And so we submit that there is no the difficulty of reconciling that with Section 35(3)(o) of the Constitution and Section 19 of the Constitution is one which is really a red herring in the context of this case, because we know that there's no question of limitation because the provisions must all be read together. The thing that takes away the entitlement to appear in the National Assembly as a member is the substantive part of Section 47(1)(e), not the proviso. And there's no difficulty with reading that consistently with Section 19. And we would also submit with respect that the tenor of some of the questions to our learned friends for the IEC seem to indicate some doubt about whether the Zuma contempt judgment was correctly decided. And that is a debate which we don't enter into on behalf of the amici, but we do submit that this case is not the proper case for that matter to be decided. If this court harbors doubts about whether the finding that Section 35.3.0 is not impermissibly limited by an order of summary conviction and sentence, the way to remedy that, if it were to be decided to be wrongly convicted, would be in a case where that issue arises and falls to be decided. And then, at that occasion, this court would be able to decide, in accordance with the doctrine of precedent, that its previous decision was clearly wrong and should be overturned. We don't submit that that is correct, but the most important submission is that you cannot fix whatever one may consider to have been errors in the Zuma contempt judgment by artificially and inappropriately forcing an interpretation onto the proviso of Section 47(1)(e), which that proviso was not designed to bear, and which its language does not carry through, and which we submit, in fact, subverts the order of judicial hierarchy, because the effect of that interpretation is that contempt of this court, which we say is one of the most serious crimes you can imagine, is treated less seriously than a contempt of a court lower down the judicial hierarchy. And that could never be a proper interpretation of Section 47(1)(e). Justice, Deputy Chief Justice, I'm very happy to waive the rest of my protected time if there are any questions.
Colleagues, do you have questions?
Thank you, Mr. Ferreira. You make the point in your written submissions for, I think it's for KSAC, that the Sarachandra Rabba judgment has been followed numerous times. You also made the point that, which is correct, even in the United States versus Benz is one of the cases. But you also make the point that, or you also made the submission that it's on all fours with this case, but not quite. If you read the Indian Act of 1951, the Section 7B of the Representation of People Act, it reads thus: a person shall be disqualified from being chosen as a member of either House of Parliament or of the Legislative Assembly or Legislative Council of State if he is convicted by a court in India of any offence and sentenced to imprisonment excuse me, for not less than 2 years, unless a period of 5 years or such less period as the Election Commission may allow has elapsed since his release, close quote. So there are two common features. It's the disqualification in terms of offence and imprisonment, which is 2 years in this instance. And the second one is that there's a period of 5 years. Once that's elapsed, it's over. But there's no proviso in the sense of where there's an appeal pending. So I suppose it could be argued that that's an important difference.
Yes, Justice Majid, I accept that distinction. We rely on the Indian case only in the context of the effect of remission, not in relation to the proper interpretation of the proviso. So I accept that that case has nothing to say about the proper interpretation of the proviso.
Yes, thank you.
Mr. Ferreira, I just want to test this proposition. The effect of the proviso is to mitigate or suspend the disqualification. And does it operate immediately, or you have to exhaust your other rights, i.e. appeal and thereafter? And I'm asking you that question because I want to contrast it with the effect of the proviso in relation to the position of Mr. Zuma. It appears to me that the proviso in the section applies differently or to different category of persons, and it becomes, it applies to different categories of persons because of the forum, that is the court in which you are appearing.
Yes, Justice Matopo, we don't agree that it applies differently to different categories of persons. It applies equally to every person convicted of an offence of more than 12 months. The time at which their sentence and conviction become operative for the purpose of Section 47(1)(e) will be different for each one of those sentenced persons. It may be when your application for leave to appeal is dismissed from the magistrate court. It may be when you decide not to try to appeal. It may be, and the submission we make is that it's only about setting that time at the point when finality has been achieved. And for every person convicted, finality is achieved at some point, and that is the time when it becomes operative. And for Mr. Zuma, because finality was achieved when this court sentenced and convicted him, that is the time when the proviso rendered the substantive disqualification operative. So we don't accept that it operates differently depending on different prisoners.
Do you accept or you don't that Mr. Zuma is immunized from the provision of Section 47(1)(e)?
I'm sorry, Justice Matopo, I'm not sure I understand.
As the Electoral Court found, that a person in the position of Mr. Zuma is immunized from the disqualification in terms of Section 47(1)(e)?
No, Justice Matopo, we submit that that finding was wrong because it subverts the relationship between the procedural proviso and the substantive disqualification, and it reads the procedural proviso, which sets only the time of operation, as carving Mr. Zuma's sentence out from the category of sentences that the substantive disqualification applies to. So we say that was a fundamental error that the Electoral Court made and which this court should overturn.
Mr. Ferreira, thank you for your submissions. I wanted to ask you, I was a bit concerned about the distinction between procedure and substance that you drew so strongly in your papers, and I thought it was a bit unfortunate you used this Pickford's case in relation to two different types of prescription statutes. I'm on page 4 of the Ahmed Kathrada Foundation, paragraph 6.2, and you talk about a distinction between a statute which extinguishes a right and those which merely bar remedy by imposing a procedural bar on the institution of an action. This is from the case itself, to enforce the right. And it seemed to me that actually here we have a case of procedure having a very strong substantive effect. And so the relation between procedure and substance, often convenient to draw, is not that easily drawn. And I just wonder if you need that for your submissions, because potentially there is a substantive effect in 47 as well, which is that it suspends the disqualification until the end of the appeal as well. And so I wasn't sure how far you wanted to take that point, but I was concerned that you would be putting a submission to us to take our jurisprudence to push a distinction that doesn't hold up and not to recognize the substantive effect of procedural issues.
No, thank you, Justice, and I'm grateful for the opportunity to clarify. You'll see the court has had plenty of paper to read, and I'm sure it hasn't read every footnote, but we acknowledge that in our footnote dealing with the Veltman decision, that this court has actually recognized that the distinction is often quite illusory when it comes to determining the effect of the provision. And a better way to phrase it may have been to say you have to look at the two sections of 47(1)(e) and see what they do. The first part sets the substantive disqualification. Let me not say substantive. The first part disqualifies. The second part determines when the disqualification becomes operative. So one needn't get too drawn into that distinction. Thank you, I'm grateful for that.
And one last point just about, I don't want to have a long debate about the Indian case law, but you put to us the 1951 Sarachandra Rubber judgment. There was a response by the respondents saying that the more recent Jagdish judgment in some way sort of qualifies what is said there and has a different effect on remission. To me, it's rather ambiguous because it says it mitigates, I think, it makes it clear that it's the power of the judiciary to really institute sentences, but remission mitigates the sentence. It's not quite clear what that exactly means, but I wanted to just give you an opportunity to address the more recent decisions. There's also one, I think, called Mandal.
Yes, thank you, Justice. The recent decisions don't deal with the same question. If you look at paragraph 4 of Jagdish, it states the question that was being decided in that case. And the question which was being decided in that case was, let me just get the word exactly right, it was a question of whether the policy which makes a provision for remission of sentence should be that which was existing on the date of the conviction of the accused, or should it be the policy that exists on the date of consideration of his case for premature release by the appropriate authority? It was a case dealing with something quite different. Our learned friends are right that those statements are contained in that judgment, but they're all obiter dicta because the case was just dealing with something completely different.
Thank you, Mr. Ferreira.
Thank you, Mr. Ferreira. Shall we take a comfort break just for 10 minutes? We'll be back at 10 past 4, 11 minutes past 4.